Everybody, so this tutorial will cover the law relating to the rules of causation. Now, we've already looked at how criminal offences are made up, how they are constructed. And to recap that, remember there are two key elements. There must be the physical act, in other words, the actus reus of a crime, but also the state of mind, the mental element of a crime, which is the mens rea. Now, causation rules kick in where an actus reus needs a result to be proven. So we not only have to prove that a physical act occurred, but that the defendant or the accused caused that act. And these rules, as I say, kick in relation to result crimes. Anything where the crime itself requires a result to be proven. So think about when you watch criminal investigation or drama programs. You'll hear and often hear references by the police or by prosecution to needing to provide evidence of injury, so maybe photographs, swabs, DNA samples. But if there's a death, then there needs to be a body. So in order to be able to charge somebody with killing a victim, there has to be proof that that victim has died. And if we're going to charge murder or manslaughter, that killing has to have been unlawful. But in order to charge a specific defendant and convict them, we have to prove that that defendant caused that death. This is where these rules kick in. Most of the time, it will be really straightforward and obvious. Defendant stabs, kicks, shoots, punches victim, victim becomes injured or dies, and that chain of causation is intact and straightforward. But what happens if there are potential incidents that occur in between the act and the death or injury that may break that chain of causation and limit or remove the defendant's liability altogether? And that's where sometimes examiners will test your knowledge of these rules by putting something into a scenario to see if you understand that. So I'm going to take you through these rules now. So for result crimes and for the OCR specification, these are those that require an outcome as part of the actus reus, so a killing for murder or manslaughter, injury of some degree from your lowest level battery or fear or panic if it's assault, up to your most serious grievous bodily harm. Okay? So to recap, once we've established what the unlawful act is, be it killing or injury, we have to prove that the act led to the harm of the victim. And the defendant must have caused that harm or death. If there are any intervening acts, then the chain may be broken, meaning that the defendant or the accused will not be liable for that crime. So let's just have a look at a classic problem then. So Lewis pushes Dave off the Empire State Building. Unknown to him, Reginald is firing his gun out of the window of a room on the 43rd floor. As Dave falls past Reginald's window, one of the bullets hits him, killing him instantly. Dave hits the floor. And the question for the police and the prosecution would be, well, who is legally responsible for Dave's death? Do we charge Lewis? Do we charge Reginald? Do we charge both? So have a think about who should be legally responsible. And what would be a good idea is once we've looked at the rules, you go back to or come back to this problem and see if you can make a decision about that. Okay, when we think about causation, we think about a chain of events occurring, and we can move or bring that chain back as far as possible. The one event has led to another and another and so on. So it could be that you believe that both could be responsible, but it would be, as I say, a good idea to come back and see if you can make a decision after we've looked at the rules. So there are two tests that we need to apply, or two rules we need to apply for causation to be established. One of those is based on the facts, and it's what we call factual causation needs to be established. So based on the facts of the case, did the defendant cause the victim's death or injury? You can add there as well, okay? And there is a bit of an amendment here that I've made, so just check this against your booklets, please. This is the correct up-to-date version. So we apply the but-for test. So the question is, would the victim have suffered harm but for the defendant's actions? Okay? So basically, if the result would have occurred in any event, then the defendant is not liable. We need to think, would the victim have died or suffered harm if it wasn't for the defendant's actions? If we think they wouldn't have been in that position, then of course the defendant will be liable. Okay, so case examples will illustrate this much easier than me trying to explain the test without that. So let's look at two here. So the case of Paget in 1983. So Paget was being asked to surrender by the police for a number of different offences. He essentially took his pregnant girlfriend from her home and held her hostage. So the police had turned up and asked him to surrender. He came out of her home, holding her in front of him and firing at the police. They returned fire at him and the girl was killed by their bullets. Okay. He was charged with her death, and he argued that he wasn't the cause because the police, she'd been killed by the police bullets. He argued what we call third-party intervention. Somebody else had killed her, not him. He was unsuccessful because the court, applying this factual causation test, said that the girl would not have died but for him using her as a shield. So his actions led to her death. Okay. In contrast, we've got a case where the but-for test is not made out. The case of White, which is an earlier case, 1910. So White wanted to kill his mother, and he put a poison in her drink, intending to kill her. However, she actually died of a heart attack before she could drink it. So applying the factual test here, but for the defendant's actions, she would have died anyway. So he was not the factual cause of her death. I wonder if you can think of what he would have been charged with instead. If he intended to kill her, he'd taken steps to kill her as well, physically, but didn't actually cause the result in the end. And hopefully you're thinking about attempted murder. He was guilty of that in the end. Okay, so that is the factual test. So we're going to go on to the second rule, which is of establishing legal causation. And there is a legal question to ask with regards to each case that we look at. The question is whether the defendant made a significant contribution to the death or injury, or whether they were the substantive or operative cause of that death or injury. So what part did the defendant have to play? Did they contribute or not? And the rule that I really like in relation to this legal test is the de minimis rule. So what this says is that for a defendant to be liable, their actions must be more than the minimal cause of death or harm. They do not have to be the sole or main cause, but they must be more than the minimal cause. We can only make that judgment based on the case and the role that the defendant had to play. And what this actually means is that more than one person may have contributed and may be liable. Because everybody who is accused of a death or injury may have had a part to play. And this could be, if you think about gang crimes, our rules of joint enterprise, charging more than one person for the death of a victim. It absolutely reflects this rule in that people can be jointly responsible for one outcome. You only have to have played more than a minimal part in that result. Okay, and this is illustrated quite nicely in Kimsey. This is the leading authority. So Kimsey was involved in a high-speed car chase with a friend. She lost control of her car, and the other driver was killed in the crash. So the evidence at trial wasn't very clear what had happened just before Kimsey lost control. There wasn't overwhelming evidence that she had been the main cause of the crash. But despite this, using this principle, the judge directed the jury that Kimsey's driving did not have to be the principal or substantial cause of death, as long as there was more than a slight or trifling link, they said. So it was more than, as long as Kimsey's actions were more than the minimal cause, then they could be convicted, and they were, and upheld on appeal. So if you were to go back to that first scenario I gave you with Dave being killed, if you were to apply the both of these tests that we've gone through now, both of these rules, you could argue that but for Lewis pushing Dave off of the building, he would not have died. You know, he must be factually responsible. Could you argue that but for Reginald's actions, that Dave would have died? I'm not so sure. I mean, Dave falling off the Empire State Building was falling to his death regardless. So I think there's a potential question mark over Reginald here. And particularly if we were to kind of jump forward with Reginald's mens rea too, you know, his state of mind. I mean, as far as Reginald's concerned, he's firing out of a window where you wouldn't expect anybody to be. Whereas Lewis quite clearly has intention to kill, and I hope you agree with that. So certainly the but-for test could be established for Lewis. But then if we think about the legal test, they both have jointly contributed to the death of Dave. However, what I would say is both tests have to be made out. So if we're saying yes for both for Lewis, then Lewis would be legally responsible. If we're saying overarchingly yes for one for Dave, then Dave would not overall be responsible. So it would be interesting to hear what you think about that. What is important to also consider is whether there are any exceptions, any actions that might break this chain of causation that cuts the but-for off and removes the defendant of liability. There are three main, what we call intervening acts, and these are known in Latin as novus actus interveniens. Okay, so any unreasonable actions of the victim that contribute to their death or injury may break the chain of causation. These have to be unreasonable, though. And in determining whether they're unreasonable, they have to be unforeseeable. So it cannot be foreseeable that a victim would act in a particular way. It has to be unforeseeable in order to be unreasonable. So thinking about, is it quite reasonable in the way that the victim acted in that situation? If it is, then that action will not have broken the chain of liability for the defendant. We'll have a look at some examples in a minute. Unreasonable actions of third parties may be deemed to break the chain. Finally, any medical treatment administered to a victim that is deemed to be what the courts have coined or referred to as palpably wrong may break the chain of causation. And we'll have a look at this in a minute. There are two other areas that have potentially been considered as well. One is turning off the life support of the victim, which of course would cause their death. Has that been considered to relieve the defendant of liability? Hopefully you'd be thinking, well, no, of course not, because but for the defendant's actions, the victim would not need to be on life support. So the defendant, of course, is factually liable for a victim's death anyway, but also is more than the minimal cause of their death. So the chain of causation would still be intact. So that does not break the chain. But also there's another rule that's formed through a number of different cases. And this is where a victim may choose to refuse treatment or may be more susceptible to injuries due to pre-existing conditions, and in terms of refusing treatment due to their own beliefs or state of mind. What if they die and they could have lived had these things not have existed? Defendants have sought to argue that these have caused the death rather than them before. But both of these do not break the chain. So we'll go through the supporting authority for those in a minute. So let's have a look at the first one. So bear in mind, you're only in a scenario applying any of these if they are there on the facts. There's something that occurs that you think, oh, okay, the defendant might not be responsible. One of these intervening acts might apply. So firstly, unreasonable actions of the victim. So we have the case of Roberts here, okay? So the case of Roberts, so Roberts met a young woman at a party and basically offered to give her a lift to another party. So it was in the middle of the night, I think it was 3 a.m. or thereabouts. Roberts gave a lift to this lady. He obviously took a shine to her and drove her to a remote place before going to this next party, and tried to make sexual advances towards her. She very clearly refused, and Roberts became a bit angry by this, or agitated, and drove off. So left the remote place at speed with her. She was still in the car. Whilst they were then driving to this next destination, he started trying to take her coat off whilst he was driving. So he was touching her coat, trying to take it off. She obviously kept refusing, but he wasn't stopping. So in the end, obviously scared and panicking, she jumped out of the car. Luckily, she didn't die. She suffered injuries to ABH level, so multiple bruising. So she was very lucky that she didn't die from this action. Now, when Roberts was charged with causing actual bodily harm, he argued he wasn't the cause of those injuries. So he said that her actions broke the chain of causation. She acted unreasonably by jumping out of the car. So I wonder what you think about this. What would a court say? They said it was quite foreseeable, whether by the defendant or not, but certainly should have been foreseeable by the defendant, that if he is going to assault her in the car, then she may take steps to remove herself from it. So her actions did not break the chain of liability. But for his actions, she wouldn't have jumped out of the car. His actions were more than the minimal cause of her harm. Okay? But in contrast, we have a case involving two defendants here, William and Davis, where they picked up a hitchhiker and were giving him a lift somewhere. And they all seemed to be getting along. But they were joking, the defendants between them, about robbing the hitchhiker. Apparently on the facts, it was very clear that this was a joke. Anyway, this hitchhiker also jumped out of the car, but he was killed. And these defendants sought to argue that they hadn't caused his death, that his actions were unforeseeable, and totally unreasonable, and therefore they shouldn't be liable. And they were successful. So it would be for us, to make a decision on the facts. Are the actions of the victim foreseeable, reasonable or not? And if you think they are reasonable or foreseeable by the defendant, then you would still conclude that the defendant is liable. Okay? Very much the same for any actions of a third party. Are they unreasonable? If they are, they will break the chain. If they're reasonable, they won't. So Paget is a good example of this. The actions of the police were deemed not to be unreasonable. Sometimes the police have to make really tough decisions and shoot with the possibility that somebody innocently might be harmed. Now, I'm not sure that this would happen in current day and age, but in 1983, certainly Paget was held responsible and the police were not for the death of the young lady. The case of Rafferty is a really interesting case. So this was a case where a number of different defendants were beating up a victim on a beach, and one of the defendants decided to leave the victim, so he didn't want to carry on, and he instructed the other two to leave the victim alone. Now, the victim was still alive at this point. The first defendant left and went to apparently withdraw money. The other defendants, unbeknownst to the first, actually carried on beating the victim and drowned him and killed him. And the first defendant was able to successfully argue that the other defendants had caused the death of the victim, and their actions had broken his chain of liability because he'd chosen to remove himself from the situation. So it's worth also, if applicable, looking at if there are a number of different defendants, who has committed what. And if anybody's left the scene, of course, timing is really crucial, but that may actually relieve them of any further liability there. Okay, the third one, if there has been any medical treatment that is considered palpably wrong. Okay, this is a term from the courts. So this comes from the case of Cheshire in 1991. So Cheshire shot a victim in the thigh and stomach, and the victim needed major surgery as a result. He developed major breathing problems and was given a tracheotomy to help him breathe. 2 months later, the victim died from rare complications left by the tracheotomy, and his original wounds had healed. Cheshire sought to argue that he had not caused the death of the victim. in actual fact, he sought to argue that the medical treatment the victim had received afterwards had broken his chain of liability. The court refused this argument and held Cheshire liable, and they really clarified what the position is in relation to palpably wrong, negligently wrong treatment. They said the negligent treatments, remember, negligence is where you owe a duty of care to somebody. So as a doctor or a hospital, you owe a duty of care to your patients. If you fall far below that treatment expected, then you may be liable in negligence. And this can be civilly, could be criminally, if you cause their death through that negligence. Now, if we're thinking about whether a doctor has fallen below the standard expected in treating somebody, we do have to compare their actions to those of other competent doctors or medical professionals in that field. This is something that we will look at in more detail when we learn about negligence through tort law in year 13. So what the court said here, bearing in mind this is a criminal case, the court said the negligent treatment must be so independent of the defendant's actions and in itself so potent in causing death that they regard the contribution made by his acts as insignificant. And if you think here, well, are his actions insignificant in leading to the death of the victim? Well, as a result of the shooting, the victim needed the surgery and developed problems as a result of those original injuries. So if we use the but-for test, we can relay the chain of events back to Cheshire. This treatment is not so independent of the defendant's actions, okay? And it's not just about this legal test, really. This is a policy decision that the courts adopt too. Thinking about the wider effects of finding defendants not guilty and holding doctors liable when what they are, in the most cases, trying to do is save victims from life-threatening injuries caused by the defendants. If they were to find doctors liable, then that would simply open up the floodgates for claims against doctors. So financially, socially, economically, the courts could not be seen to be doing this. Very rarely will negligent treatment break the chain of causation. It has to be in itself so potent in causing death, and they call this palpably wrong. Does it fall so far below the standard expected and there is a risk of death in their actions? Okay. Now, obviously, they tried to give the victim here something to help them breathe. That in itself is just not falling far below the standard of care expected. Sometimes these treatments do result in death. That doesn't mean that the defendant should be relieved of liability if they have been the underlying cause for the victim needing that treatment. You might remember me telling you a story in class, a local case where a victim was stabbed with a screwdriver by a defendant. I don't know if you remember me telling you about that, and how the defendant sought to argue that the injuries, when the victim had been injured, he needed to be treated with or fed through a feeding tube, so he was left quite severely disabled, and he died some years later. The defendant tried to argue that he hadn't caused his death because he died in part from complications with the feeding tube. And of course, you know, if we're going to relay that but for test back, but for the defendant's actions, the victim would not have needed that tube. And here, but for the defendant's actions, the victim would not have needed this surgery. Okay. There is, however, a rare reported case, if you look at the bottom of the screen, of Jordan, where there was a break in the chain decided by the courts in relation to medical treatment. So do look that up, but that is very rare. So two things that don't break the chain, just look out for them if they're in a scenario. They have been known to come up. This one not so much, but if a doctor turns off the life support of a patient, remember when we talked about the Anthony Bland case, Airedale, NHS Airedale Trust, asking the court to make a declaration that they could turn off the life support of Anthony Bland and that they would not be failing in their duty of care to him if they did so. A doctor's duty is not always to keep a patient alive and make them better if it's not possible. Sometimes their duty of care can be to end treatment if it's in their best interest, and of course to make them as comfortable as possible. And the case of Malcherek and Steele, these were two defendants who joined together to argue that where their victims had had their life support machines turned off, these defendants should not be liable for their deaths, and that the life support action should break their chain, which of course the court said, no, that's not true. And it really comes down to, in the cases of Malcherek and Steele, their victims were already in a state where they were deemed arguably not to be alive. So where doctors test a victim and determine whether their life support needs to be turned off, they do, obviously I'm not a medical professional, but I know they will test for the level of brain activity, and they will check whether what's called the brain stem cell is intact. Okay, so if there's a level of activity there, it could be that a patient can continue to remain on life support and may regain consciousness. But if they deem that the victim's injuries are so severe and that brain stem cell is not intact, then arguably they're not clinically alive anyway, so to speak. So in both cases, for Malcherek and Steele as defendants, their victims' brain stem cells were not intact, so they could not successfully argue the life support or the turning off of the life support machine broke their chain of liability, which hopefully you all understand, and that makes sense. As I referred to earlier, sometimes defendants have sought to argue that if victims refuse treatment or they have a particular pre-existing condition that has contributed to their death, then perhaps that breaks the chain of liability. The courts have ruled in a famous case of involving a defendant, Blau, in 1975, that you must take your victim as you find them. And they also refer to this as the thin skull rule in criminal law. So if, and a judge famously said, if somebody has a thin skull and they are injured, they suffer a head injury, and that thin skull makes them more likely to die, that does not relieve the defendant of liability. In civil law, this same principle applies in relation to finding of negligence, and it's called the eggshell skull rule, if you're interested. But in criminal law, it's called the thin skull rule, and you must take your victim as you find them. You cannot argue that you're not liable because you didn't know of a particular belief of the victim, state of mind, or pre-existing condition that has contributed to the death. So the famous case here involved Blau, who stabbed a young lady. She needed a blood transfusion to save her life, but she refused one due to her religious belief as a Jehovah's Witness. So she ended up dying, and that, of course, caused her death. Blau tried to argue that her actions had broken the chain, but he was still convicted of her murder. And that's because you must take your victim as you find them. but for his actions, she wouldn't have died. And his actions were certainly more than the minimal cause, okay? So I hope that that all makes sense. So I'm going to put up a summary slide here, and what you should do is take some time to complete it. So write in the factual test, use one of the supporting cases, write in the legal test and cite the supporting case there. You could put those cases in brackets, that's fine, after the test. Write out the intervening acts with a case for each. There are some other really interesting intervening acts cases online. Marjoram, Marjoram, from the year 2000 is a really good one for unreasonable actions of a victim, or rather in that case, reasonable actions. So her actions didn't break the chain. So there are others that you could look at as well. And then you've got the two other legal rules at the bottom, the pre-existing conditions and turning off victims' life support. Okay, so I will leave you with, you're going to have a worksheet set by me with some short causation scenarios, but I'll leave you with the first causation scenario to have a go at practicing. And this is in relation to Ben's liability for Aled's injuries. So as I say, there'll be some other scenarios on the worksheet and you need to complete these all in your next lesson. First one, Aled has been threatened by Ben in the past with physical violence. When Aled sees him approaching him in the street, Aled runs across the road without looking and is knocked down and injured by a car. Would Ben be liable for Aled's injuries? Okay, so I'd like you to pause this and have a think. Is the factual causation rule satisfied here? Legal causation, are there any breaks in the chain that may prevent those rules from being formed? And then what I'll do is I'll show you, and it's in your booklets as well, I'll show you how I would structure this particular law and application of this scenario. Okay, just for future reference to show you how you'd write it out. So I'll put it up on here and you can have a read, and it would be for you to conclude whether you think that Ben would be liable or not for Aled's injuries, okay? So that concludes our tutorial for causation. I hope you've found it useful. The next step will be to look at the final construction element of a crime, which is mens rea. So the state of mind. So we'll look at mens rea. We will also briefly look at some other principles relating, such as transfer of malice. And then we will tie it all together at the end with the principle of contemporaneity, which means that the actus reus and mens rea both have to cross over or meet at some point for a defendant to be liable. And then after that, we will start looking at offences, and we'll start with the first kind of arguably not a criminal category of offences, but more regulatory offences of strict liability. But then after that, we will go on to our truly criminal offences, starting with the most serious of murder. So I hope you found this useful, and please do take your time to go back over it if you need to and make sure you've got all of your notes. Thank you.